I want to address the general hardship that's imposed on someone who seeks to prove that it lacked the requisite mental capacity on a certain date when that decedent has not.
Well, and I understand your argument about that, but it seems to me that your client was in the best position to offer that testimony, since she actually witnessed one of the signatures on that day and could have said, she did not have the capacity or something similar to that, and instead she signed it. So it seems like that cuts against your argument about how difficult it is to establish the lack of capacity.
Well, Judge, with all due respect, I think the best, sorry about that. I think the best evidence would not have been from Kimberly Webb, who did witness the document that assigned the defendant in this case, Michael Webb, as the attorney, in fact, on a durable power of attorney, who then, as the evidence showed, went on to, instead of using that durable power of attorney in his mother's best interest, sent his mother, who he knew had been declared incompetent, sent his mother, who he had called her attorney, to tell the attorney, hey, my mom's incompetent, what do I do? And the attorney says, you've got her power of attorney. Instead of using the power of attorney, he sends his mother to his fraternity brother, and who then has her sign a 70-page contract. I'm holding up Plaintiff's Exhibit F.
Well, can I ask real quick? So before she signed the contract, she had already been declared incompetent?
So before she signed the contract, she had been assessed
by
Dr. Walden. Yes. Okay. So what I meant, Judge, was that the Dale Clockey was the attorney for the decedent in this matter. And he testified that Michael Webb called me a month before the date in question, which is February 25th, 2009. So the defendant calls Mr. Clockey a month before and says, my mom's been deemed incompetent, and asks what to do. So that was Dale Clockey's testimony.
Mr. Ernst, let me interrupt you again. I know we're peppering you with questions, but there's a difference, is there not, between being incompetent and unable to handle your own affairs in that sense, and not remembering things and having difficulty living on your own and needing assistance, between that and the testamentary capacity that we're talking about, which is knowing the bounties of among other things, knowing who your heirs are, who you have affection for, and recognizing your relationship to them and having a general understanding of your assets. Isn't that quite a different test than whether or not somebody has dementia?
Well, yes, Judge, they are different, but I do think that evidence that you're incapable, as Dr. Warren said, is that she was not competent to make the decision in her own best interest as to where she should be living. Should she be in a nursing home or not? I believe that does give weight to the question of, did she understand the nature of the transaction that she engaged in on February 25th, 2009? So I think if we
wasn't the testimony that she contacted Mr. Lee, and that Mr. Lee met with her separately in person and on the phone, and she was able to articulate to him what she wanted to do. In other words, move her assets, among other things, because of the financial instability of the prior investment advisor.
So yes, Mr. Lee's testimony was that Betty Anderson, the decedent, contacted him at the request of direction of Michael Webb.
Well, wouldn't that be normal for a son and an elderly mother to say, hey, Mom, your IRAs are tied up over here. I'm really concerned that you may lose them. Here's the name of my college fraternity brother. Wouldn't that be normal even with somebody not suffering from dementia?
No, I don't think so, Judge, because in this case, Michael Webb testified. Actually, Dale Clockey testified. No, I'm sorry. This was Dr. Brewer testified that a month after the date in question, Michael Webb told her in an interview with Dr. Brewer that my mom can't handle her money and she can't handle paperwork. But then he sends her to a financial advisor when he is her attorney. In fact, he could have done this himself. So no.
So would you have us void that entire contract And then where would the assets go? Back to the bankrupt company?
Judge, I think the court would have to trace the assets back to the bankrupt company and or the last known beneficiary. The last known beneficiaries was at the financial institution before Stanford, which had the account being split 1/3, 1/3, 1/3, which is the only way that we know it was before it was transferred all to Michael.
I'm not talking just about the beneficiary designation. Under your argument, we would have to void the entire contract.
Yes, Judge.
So-
Our argument is that
So, I mean, how could that possibly happen? Are you saying then that all of the interest and any money that was earned goes back to UBS, Wells Fargo, or I can't remember which entity it was? I mean, you want us to unwind that entire transaction,
well, Judge, this is a contract.
right?
This wasn't just a her going and changing a beneficiary. This was her entering into a contract. And our argument is that she did not have the mental capacity to enter into that contract. So if the result of that is that it is void, yes, there would have to be an unwinding process. Would it be difficult? Probably, but I'm sure it's been done before and it can be done again.
So is your position that if, let's say I'm a high school graduate who never studied the law and never studied finance, and I go in to a financial institution, is your argument that I have to understand every bit of that 60-page document or else I'm incompetent and then the contract is void?
No, Judge, I think you have to understand the nature of the transaction. And the nature of the transaction is the contract. Now, do you have to understand what every single word in that contract is defined as? No, I don't think so.
But where's the evidence that she did not understand the nature of the transaction?
So that was Dr. Brewer's testimony, was that on February 25th, 2009, Betty Anderson was suffering from dementia, and that dementia was having significant impairment upon her cognitive facilities that made it extremely unlikely she was able to comprehend the contract that she signed on that day.
Well, but I think this is the disconnect. The testimony, and that's what I recall, was that she didn't necessarily understand the contract, but there's a difference between understanding the contract, to Judge Meyer's point, and understanding what the gist of the transaction is. Like, I'm moving my money from here to here, and the beneficiary is now going to be my son, Michael. Like, someone with dementia who can't understand a contract can understand those basic points, or could.
And I understand that, but at the same time, Dr. Brewer's testimony, that was the evidence that we presented to show that she did not understand. She didn't have the mind and the memory to understand the nature of the transaction.
Yeah, hey, Bob.
What was your complaint? Was it seeking a declaration to strike the beneficiary designation or to void the entire contract?
I believe count one was for a declaration to void the entire contract.
Okay.
Wasn't the testimony from your client that her mother did know who Michael was, knew that he was her son, knew who she was the daughter, knew who Kyle was, and understood her relationship to all three of them?
Based on my recollection, yes, that was my client's testimony, but we believe that the best evidence as far as somebody's mental capacity to contract is going to come from a clinical and forensic psychologist who directly examined and administered psychological testing on the decedent a month after the date in question. And she also reviewed the assessment.
I've never seen it done. I mean, usually
Mr. Waters,
the final word.
Mr. Waters, if you can hear us, your microphone is on.
Yeah.
If you could turn it off there. Go ahead, Mr. Ernst, why don't you repeat that last point?
Thank you, Judge. I
And
think
I'll give you some additional time.
The best evidence would be Dr. Brewer, who's a clinical and forensic psychologist who personally interviewed the decedent a month after the date in question, and also reviewed Dr. Walden's assessment that was done a month before the date in question. So we have the date in question sandwiched and we have Dr. Brewer's expert opinion, which was the only expert opinion. And as a matter of fact, the defense did not present any evidence that on February 25th, 2009, that she did have the requisite mental capacity. Dr. Brewer is the only one who said on this date, that is a difficult thing to have an expert do, to have an expert go back, this was in 2009.
Can I ask you a quick question on her testimony though? I thought that the judge kind of relied on the fact that she did testify that there are periods of lucidity, and that, based upon the other, so she said, yeah, there can be times where she's not experiencing this confusion. And then based on the other testimony of the people who actually dealt with her on the date that she signed the contract, who said she seemed fine. I mean, how do you get around that testimony from Dr. Brewer?
Well, I think you have to look at Dr. Brewer's credentials and the fact that she performed psychological testing on her, and this is her expert opinion. And I understand that a lay witness can interact with somebody for 10 minutes and say, hey, they seem fine with me, seem fine by me. But here we have an actual expert who's saying, here's everything I did, here's everything I considered, and I can give you my expert opinion. And my expert opinion is that it is extremely unlikely she understood what she was doing. Extremely
well,
unlikely.
no. Let me ask you this, and I'm sorry, I want to hone in on this, because there's a difference between being able to understand that 60-page document. I think her opinion, and correct me if I'm wrong, was that it was extremely unlikely that she was able to read or comprehend the agreement she signed, which
Correct.
is different from being able to understand the nature of the agreement, what she was doing, who she wanted her money to go to, and who her heirs were. Those are two different tests, and that's why I keep coming back to that.
Sure.
Dr. Brewer did say she couldn't read and understand that 60-page document, but I suspect most people couldn't.
Okay. In regard to that, the nature of the transaction is contained in the document itself, in the contract. I mean, this is the business that was transacted, and Dr. Brewer said she didn't understand it. So I think that is evidence of a lack of testamentary capacity. Now, did Dr. Brewer go further and say, well, on page 6 of this 77-page document, there's a pre-printed, beneficiary designation. Dr. Brewer unfortunately wasn't there and doesn't know if Michael Webb couldn't remember. And actually he said he did. This is her attorney in fact testified that he handed his mother a 77-page document and he didn't look through it with her.
And you are at your time, even though we peppered you with a lot of questions. If you want to reserve 3, you're at your time.
Thank you, Judge.
All right, Mr. Hawes.
Good morning. And I think the questions asked by the panel kind of took away some of my thunder under the arguments made by Mr. Ernst in his brief. I think what's really important, well, yesterday I was getting ready for this and I was getting my temperature taken at one of the courthouses. And it kind of gave me an idea about what happened here and what Dr. Brewer was relying on. Dr. Brewer essentially relies in part on a statement in a medical record from Dr. Walden that says Betty suffered from dementia NOS. And we know that could be anything, and Dr. Brewer explained that really didn't mean much. Well, it's kind of like Dr. Walden saying, well, one of the nurses put her hand on Betty's head and it felt warm. And here's Dr. Brewer testifying a month later saying that warm hand on Betty's head means that she had a fever. Well, that's not what it meant. Because when you go to the transcript, when I talked to Dr. Brewer, and I'm not going to read pages 61 through 75, but I believe they're instructive. Dr. Brewer performed some tests on Betty, okay, some real tests, okay? And then Mr. Ernst in his response is going to say, well, that's just part of it, okay? Well, yeah, it is part of it, but it's an important part. And when she did these tests, Betty tested pretty high, okay? And in her position at trial, she wanted to indicate that Betty was severely suffering from dementia. Well, that's not what the test shows. The MMSE.
But Mr. Hawes, wasn't the evidence that she couldn't name any president except for George Washington? That would indicate, Kate, wouldn't it, even to a layperson, significant impairment?
Well, I understand what you're saying, but the testimony, okay, is that she tested a 19, which is on the edge of mild, okay?
Well, but I think, so where I got a little confused on all that was, who is saying that's on the evidence of mild? And I thought her testimony was that it was a significant impairment. So you or I could read those tests and can look them up on Google and figure out what they're supposed to show, but that's us interpreting the test. My question is, did someone testify that that was indicative of mild impairment?
Well, yes, on page 64, Your Honor, line 13, the doctor testifies, all right, it does give the range here of the scores and the interpretation, and we're going down here to severity. A 17 is severe cognitive impairment. Her first one, meaning her first test, was a 19. So it was on the edge of mild, and then she got a little worse. We're talking about 2 points, which probably mean not even really significant. So then I asked her, so it could go up and down in a matter of a day? No, not up and down, maybe 1 point within a small range. So then I made a joke. I said, well, I'm hoping I would score 25. And she says, no, you would probably do 30. Okay. And then I asked question, and that is a mild cognitive impairment according to the interpretation of the MMSE. And she says on the cusp, as you all say, all the way up to 23. So 19 to 23 is mild. That's her first test. Okay. So then, okay, so that's in the soup. That's that's one of the ingredients. Well, Dr. Brewer never talked to Mr. Lee. Okay. And Mr. Lee is the only person that gave evidence contemporaneous besides Mr. Webb. The plaintiffs in this did not call the daughter. The evidence in this case is very clear that the daughter actually came and objected when Michael Lee wanted to have his mother declared eventually incompetent, couldn't handle her affairs. She objected and said, no, my mom's okay.
And when was that temporally?
That was at the hearing that Michael Lee, in front of Magistrate Stargel, had attempted to have his mother declared incompetent. She appeared one time. It's in the record. Then they said it over, and the plaintiff in this matter didn't appear at the second portion of the hearing. The other thing that I want to point out is this. One of the judges kind of asked the question like, can a person change their mind or appoint another person today as opposed to yesterday, the brother versus the sister? Historically, and I think Mr. Ernst will agree with me, historically, Betty used her money or her estate kind of to whipsaw between the kids. But she had a problem with the plaintiff in this case. The plaintiff in this case was on some type of public assistance. And she wanted to make sure that the plaintiff in this case did not end up with the money, which would kick her off of public assistance, squander her money. And Mr. Clockey went into all of that in his testimony. Well, at one time early on in the game, Michael was the sole beneficiary. Okay. Then she switched it up and made the grandson and the daughter and Michael 1/3 beneficiaries. And then when things changed and she eventually went to Michael, my client's fraternity brother, I kind of point that out because that doesn't change the facts. She went alone, clear and convincing testimony for Mr. Lee. Nobody made him a liar. Nobody said he had a skin in the game. He just did what the lady asked him to do, and that's make put Michael in charge. And clearly there are probably very good reasons for doing so. The other thing is that when questioned, and I'd like to finish on this, Dr. Brewer really doesn't carry the ball over the end zone. Okay. When I ask her a pointed question, her question to me is, well, what do you want me to say? She loses big time, in my opinion, at that point. Dr. Brewer didn't see Betty at the time this transaction happened. We all, we as technicians of the law, we'll read all 60 pages probably. Will we understand all 60 pages? I think Judge Meyer's point is good. Betty is no different than the high school graduate who has no training in this matter and is faced with, who do you want to give your money to? Betty Anderson has answered that question 3 times. Once it was Michael, once it was the 3 heirs, and then went back to Michael. This is not a case where the plaintiff in this matter has carried the ball. I think Magistrate Stargell did an excellent job in outlining the positions. Judge Winkler then reviewed it. And I think that the case law in Ohio, in our Court of Appeals, is pretty straightforward. You can give your money to who you want to. And that's what Betty did. She gave it to Michael. And I'd like to end on that. Thank you.
Mr. Ernst, you have 3 minutes left.
Thank you, Judge. Just in response to what one of the things that Mr. Herb said was, he made it appear, at least he said, that Betty Anderson told Mr. Lee who she wanted to give her money to. That's absolutely not true. Mr. Lee testified he never discussed the topic of beneficiary designations with Betty. Mr. Lee had a very brief interaction with Betty Anderson for the sole purpose of her to say, here are my accounts at this firm that's going bankrupt, that's in receivership. I need to get my money the heck out of there. And that's all. They never discussed beneficiaries. Mr. Lee's testimony was unbelievably general. All he said was, well, she seemed sharp to me. Nothing else. I didn't have any concerns. She seemed sharp. She knew what she wanted to do. She wanted to get her money the heck out of there. There was never any discussion about who do you want to give your money to.
Well, who put
We don't
the
know.
name on the beneficiary form?
We don't know. It's pre-printed on the packet. Unfortunately, the subpoena we got back from UBS didn't have any further information as to who actually put that on there. We don't know. And her attorney, in fact, didn't know either.
Mr. Lee's testimony didn't shed any light on how the beneficiary designation got on there?
No, we don't. We have no idea who printed that on there. We don't know. All we know is that this packet, Mr. Webb took this packet to his mother and had her sign it, and he didn't look it over and he didn't review it with her. And Mr. Haas made a big deal at trial. Oh, look, on page 6, it's highlighted who the beneficiaries are. Anybody would see that. Well, Michael Webb, her attorney, in fact, should have looked at that. He knew he's her attorney. In fact, he can't be her beneficiary if he uses the power of attorney, but he can if his mother doesn't use the power of attorney.
But the evidence was that it was somebody at UBS that put it on prior to it being delivered to her.
It would have had to have been.
So it's a reasonable inference that she told somebody at UBS who she wanted the beneficiary to be.
It's not unreasonable to assume that somebody at UBS was told to do it. Yes. Who told him to do it? We don't know. As far as Mr. Haas's point about the nurse taking somebody's temperature, the difference here is that Dr. Brewer confirmed the assessment. Dr. Brewer looked at the assessment done 2 months prior and then personally examined her and said, I absolutely agree. It's like going back in time and then putting a thermometer on that person's head. She confirmed the assessment. Lastly, as far as the difference between if this was a high school student who was going to sign a contract or if this is somebody with dementia, well, if the high school student was suffering from dementia and that dementia was actually affecting their ability to comprehend the contract, that's the difference here. It's not just that somebody is younger and doesn't understand because they haven't been educated. The fact is, Dr. Brewer's testimony was that the dementia was actually affecting her on that day. that's a difficult burden for somebody who's challenging the mental state years later to be able to overcome. And as as Judge Winkler mentioned at the objection hearing, it's not easy. But if there was ever a case where a challenger was able to show that, yes, on this day in question, this person was demented and highly unlikely to be able to comprehend the contract, this is the case. With that, I'll rest unless you have any further questions.
All right. Any other questions for Mr. Ernst? Mr. Ernst, Mr. Hawes, thank you very much for your arguments this morning. We will take the matter under submission and give you a timely written decision.
Thank
Thank
you, Judge.
Thank you. And Mr. Allen, we cannot see you.
Let me check that, Judge. Hey, Janae, I need you. Can you?
There you are. We can see you
Okay.
now. We can hear you. Mr. Havlin, we can see and hear you as well. Well, we can see you.
The microphone
can
should be on. Okay.
We can hear you too. All right. The next case on our docket this morning is the case of State versus Smith. Mr. Allen, Mr. Havlin, I see you're both here, ready to go. Mr. Allen, you've got 15 minutes. Would you like to reserve any of that time for rebuttal?
I would, Your Honor. I'd like to reserve 5 minutes, please.
All right. I will let you know when you're at your time. Whenever you're ready.
Thank you, Your Honor, and good morning to you and the other judges, and also Mr. Havlin. Judge, I'd like to concentrate first and probably most on our first assignment of error. And from our perspective, Your Honor, it's pretty simple. We feel that imposing a sentence for both burglary and drug trafficking violate the double jeopardy clause, because our client, Mr. Smith, basically is being punished twice for the same conduct. As I'm sure the court knows, State versus Johnson is the Ohio Supreme Court case that we believe is right on point there. And it's a two-part test, Your Honor. It's a two-part test to determine if the two offenses are allied offenses that must be merged. Here's the first question.
Mr. Allen, could you respond as to whether this argument needed to be raised at the first proceeding, in the first appeal?
I can, Your Honor, and that's addressed in our reply brief at pages 1 and 2. Judge, we feel that that it is appropriate to address that issue here, because this court vacated his previous sentence and the trial court resentenced him. So we do not feel that res judicata prevents him from making the argument at this time, even if it was not specifically argued in his original appeal. Also,
you agree that his original appeal, when they brought up the issue of merger, it was the cocaine possession and the trafficking that they were trying to merge, right?
Correct.
So this was not something brought up at all.
Not specifically, Your Honor, but we do believe that it was addressed and that res judicata is a rule, obviously the court knows, of substantial justice, and we do feel it's appropriate to bring it up in this appeal. Just going back to State versus Johnson, talking about the test, the first question of that test is whether both offenses can be committed by the same conduct. And believe the answer to that in this case is yes. I mean, obviously you can commit a burglary and steal cocaine. A little bit unusual, yes, but that's what happened here. And the second question, if the first question is answered in the affirmative, which we believe it is here, is to look at the facts and determine if those two offenses, that being the burglary and the trafficking, and determine if those two offenses were in fact committed by the same conduct, which is a single act with a single state of mind. And again, we believe that the second test prong of the Johnson test can be answered in the affirmative, in that our client, Mr. Smith, committed the burglary and the theft of the cocaine at the same time. It
So
was one,
in your argument, if he had stolen a gun and he had been convicted of a felony, is your argument that a weapons under disability would merge with the burglary?
well, that might be a little bit different, Your Honor. However, I think you could make an argument that it would because it is the same act. Understand the point, and it's an interesting point, but again, we believe that this was the same act in the same state of mind. We believe that the answer to both of those prongs are yes, and that they are allied offenses and they must be merged. I mean, again, it's unusual fact pattern. I don't know if I've ever seen one like this before. It's basically a burglary where there just happened to be a large amount of cocaine at this, I guess it was like a private convenience store, if you will, in an apartment, and he took the cocaine as part of the burglary. Also feel that there's no indication that the legislature intended multiple punishment for someone who commits a burglary and just happens to steal drugs. His conduct in entering that apartment was to steal. That's already a part of the offense. And again,
Did he take anything else besides the cocaine? I can't remember.
I think it was money, a stack of money, cocaine, and I believe some marijuana, Your Honor.
Okay.
I think that's what it was. But again, his conduct in entering that apartment was to steal. I mean, that is already part of the offense, this single state of mind. There are some similar examples where the courts have said that separate offenses do have the same animus. You can't be punished for receiving stolen property and theft. Again, same conduct, same single state of mind. You can't be convicted for burglary and theft when the defendant's intent upon entering a garage was to steal items. And that's from the James case that we have cited in our briefs. You can't unlawfully entering a residence with an intent to commit a theft, which of course is a burglary, committing the theft, retaining the stolen goods, which is receiving stolen property, all is a single act. All of those must be merged. And that's from the Blackburn case. It's a 4th District case that we cited in our brief.
No, so the trafficking came from the fact that it was a larger amount of cocaine that he stole, right? It wasn't
Yes,
for
ma'am.
personal use.
Yes, ma'am. And one of the police officers testified at trial that in his experience, the amount was such that it would be indicative of trafficking.
So if he stole a personal use amount of cocaine and then was charged with burglary and possession, would you say the possession had to be merged with the burglary?
Yes, ma'am. And the reason for that is, again, it comes down to a single animus, single act. Yes, if that were the case, we do believe that it should be merged. And just a kind of a policy thought, Your Honor, should someone who happens to burglarize an occupied structure of a drug trafficker, again, it's a public policy issue, I think, be punished more than someone who burglarizes someone who's a non-drug trafficker. And again, that's just our position on it.
Well, I guess going back to Judge Krause's question about personal use versus a greater amount. I mean, if he took that cocaine and it's beyond the level that would be for personal use, like the only reason you would take that is if you were going to try to monetize that. So you're going to sell it to someone. I mean, that trafficking does seem distinct from the burglary.
Understand your point, Your Honor. Again, we believe that it comes down to a single act. The trafficking, if you will, because of the amount, was incidental to the burglary. Therefore, they should merge. For the remainder of assignments of error, we would submit those on the brief and reserve my 5 minutes for rebuttal.
All right. And you will actually have about 7 minutes if you choose
Okay.
to use them.
Thank you, Your Honor.
Mr. Havlin? Oh, you need to unmute.
Thank you very much, Judge. Good morning, Your Honors. Mr. Allen. I'll also start with the first assignment of error. That this should have.
We're having, you're not very loud at all, so I don't know if you
Okay.
might need to,
It's my position that
same problem. You might want to check your microphone volume,
I will try that.
because earlier we had no problem hearing you. You want to do a test?
Sure. Is it
No.
still not?
Judges, are you both having the same problem I am?
Yes. I heard him at the very beginning.
I did too.
Maybe you should log out and log back in.
We
'Cause we
can't hear you at all now. You went from very quiet to non-existent. You want to try, well,
Can Keith get him a number to call in?
yes, I think, Mr. Havlin, there's a number call in on the Zoom invitation. Maybe we'll just have to do that.
Or use your iPhone if you have the Zoom app on your iPhone. If you have an iPhone. I assume everyone has an iPhone. If they don't. Whatever phone.
Won't work with a flip phone. But now I can hear that.
We hear your phone.
Try speaking, Mr. Havlin.
Does that work?
Yes.
Better, and I'll mute my screen here.
There is an echo, I think, because there's some microphone capability on your computer.
Maybe just take the picture off and just use your phone and just, I mean,
Does this help?
Yes.
I hear that echo also.
I think if you hear the echo, maybe you have to log off of Zoom and we'll just do you without seeing you and use your phone.
Okay, I can try that. I apologize.
Well, you were perfectly fine when we began, so something happened.
Yeah, I'll have our IT people help. I apologize. This is my
No
first one.
reason to apologize, Mr. Havlin. All right, you will have 15 minutes. I'm starting your time over. So whenever you're ready, we're ready.
Okay, thank you very much, Judge Myers. So I'll start also on the first assignment of error. Obviously, it's my position that this was barred by race judicata. I think that, and these do get confusing. I admit that, but when you look at the last judgment entry, all that is vacated is the consecutive nature of the sentences for burglary and trafficking. I think the distinction here is the fact of conviction for both of those is not disturbed. And I think when you look at the Allied Offenses statute, it is concerned with multiple convictions. Those, as I said, have remained in place. And it's my position that an argument now on Allied Offenses is barred by race judicata. In the reply
so in other words,
brief,
Mr. Haviland, sorry to interrupt you, but so in other words, you're saying that on remand, they could not have challenged the merger issue because that was already, that ship had already sailed after the first sentencing proceeding.
yes, that's my position, and I think in what I was about to get to, that's a good kind of segue. In the reply brief, it mentions essentially an argument that, well, we did bring this up in the first appeal. I agree with you, Judge Krause, that it was only about the possession and trafficking in the first, but if it was brought up in the first appeal, then I think not only is it res judicata, but it would also be barred by the doctrine of law of the case. I don't think, while the sentencing remands are confusing because it looks like, well, this is an entirely new sentence, I don't think when there's a remand for a sentence, the whole thing goes away every time. I think it's just the offending portion of the sentence, which in this last appeal would have been the consecutive nature of those two sentences. And I cite in the fifth assignment of error to the Hall case from this court. I think it is helpful also in terms of looking at the first assignment of error. In that case, they talk about a post-conviction remand where this court eventually said, well, no, we can't then talk about the consecutive nature of sentences, allied offenses, and all these other things.
Mr. Haviland, it sounds like, I mean, basically, to your point, when it's remanded for resentencing, the only thing that you really can appeal is any new issues that would arise from the resentencing, right? You don't get a redo on everything.
Sure, right, correct. It's not a brand new sentence entirely. So I think in this case, we absolutely review again the consecutive sentences that were imposed. That's appropriate in this case because they were vacated in the last case. But I don't think you start all over.
If res judicata, if we agree with you and say that, or if we disagree with you and say res judicata does not apply, could you please address the argument of whether trafficking should merge with the burglary?
Sure. I think it should not merge. And I think, I guess at the outset, this was not, an allied offenses claim was not raised at sentencing, so it would be subject to plain error review at this point. I know that Mr. Allen referenced the Johnson test. I think we would look at it via the Ruff test. Ruff postdates Johnson, and I think Johnson may not be good law on that point anymore. And I think as some of the questions to Mr. Allen were, there's a distinction in this case where he's charged with a burglary and like a theft or receiving stolen property and a burglary and a trafficking. I think it could be a closer call if it's a burglary and the TV you stole from that.
What about a burglary? What about a burglary and a possession of cocaine?
I think that's closer than trafficking, but then I think we get into why you go through the Ruff factors. I think even in that case, there's an argument to say that those are dissimilar in import because the harm caused by those two offenses is different.
But what would be the difference between a burglary and possession of cocaine and a burglary and possessing a TV? I'm just asking for a hypothetical.
The television isn't yeah, well, I guess a television isn't contraband. So there's no, you can possess a TV. The
Not
other,
if it's stolen.
I'm sorry,
Not if it's a stolen TV.
if it's correct. Yeah, I think it all goes back to the rough test. So if you broke in to steal, I think a lot of these arguments today, all the prior appeals, all the other motions filed, come from this general, I guess, displeasure with having burglarized a drug dealer. And I understand that that's perhaps a unique set of circumstances. But when you look at the rough test, I think, and to go back to the television example, I'm not sure that if you're possessing the stolen television that was the proceeds of the burglary, I think that harm is the same. You're possessing the same person's stolen television that you burglarized.
Let me throw in
and it's-
another hypothetical. I gave the one with the gun. You said, well, he burglarized a drug dealer. I assume that if he burglarized a child pornographer and took some images, that your position would be that he could be separately charged with possessing child pornography, even though he burglarized that home.
Yes, and I think those are clearly dissimilar crimes, especially, with the obvious policy implications of child pornography. Yes, I think those would not merge under the rough test. I can briefly address the other assignments. I don't want to get too far into them. I think the cruel and unusual claim and the second assignment of error, the Hairston court, I believe, controls in that, just explaining that as long as the sentence falls within the range, it generally does not result in cruel and unusual punishment. And importantly, the deference that should be given to the legislature. The due process claim, it's unclear what sort of due process claim that is, and there's no due course of law challenge levied. So I think Williams v. Oklahoma will control in that. And the sentencing, I think I believe and I'm hopeful that we finally had a sentencing hearing that satisfies all the rules. The judge put his findings on the record. He incorporated them into the entry. I believe that the sentence has been imposed properly. And finally, for the last assignment of error, that consideration of that, I believe, is barred by law of the case, as well as res judicata. That was explicitly addressed in the first appeal. If there are no further questions, I'd simply ask that you affirm, and I apologize again for the technical difficulties.
No need to apologize. Any questions from the panel? All right, Mr. Allen, you have 7 minutes left.
Thank you, Your Honor. I probably won't take all those 7 minutes. I just want to hit some of the high points. First of all, with respect to the res judicata issue, we don't believe that applies in this case. In his most recent appeal, this court vacated his consecutive sentence and then remanded for resentencing. Mr. Smith was resentenced on the same 2 counts that are currently at issue before the court. The new final appealable order was issued on August 14th, 2019. And because of this resentencing, we do not believe that res judicata applies. Also, at page 2 of our reply brief, we cite that res judicata is a rule of fundamental fairness or fundamental substantial justice. It cannot be applied so rigidly as to defeat the ends of justice or to work an injustice. And we feel that would happen in this case, or could happen.
Mr. Allen, the issue is, though, he raised in his first appeal this merger argument. And I mean, this is something that could have been argued in that first appeal. and it wasn't. And my understanding of what issues you can raise on appeal after a resentencing is simply new issues that arise at the resentencing that were never issues previously.
I understand that, Your Honor. I believe, and it's been a while since I looked at it, that in the first appeal, it wasn't specifically couched in that manner or a double jeopardy violation. Again, we think it's right for your consideration at this point. And
Mr.
with that,
Allen,
yes, ma'am.
go to my second hypothetical, which was the possession of a contraband in my hypothetical child pornography. Wouldn't the logical extension of what you want us to find be that that person couldn't be charged with possession of child pornography?
Judge, it's a really good example and a really good question, and it is different. It's different than the situation that we have here.
How?
However, well, it's different in that with respect to child pornography, it's a situation where he couldn't have, if somebody did that, they had no time to share the child pornography, or yes, very briefly, very momentarily, a matter of minutes, possess it. And again, we feel that it's one act and one separate animus.
Your argument seems to hinge on this temporal thing, because, you know, if your client had been caught later standing on the street with this bag of cocaine, then would your argument would be different, right? I mean, maybe he stole the cocaine in the burglary, but it's all about the timing of when he was caught with the cocaine is what your argument seems to center around.
Pretty much, Your Honor. But if he possessed that cocaine and he's standing on the corner and he only walked out of that apartment/convenience store 3 or 4 minutes later, I do still think it's the same act, the same animus, you know, all committed and basically.
What about hours later though? I mean, it seems like your argument's all about the timing, and where's the cutoff there? If it was 3 hours later, he's caught with it.
Yeah, you know, specifically, Your Honor, as to what time you'd cut it off, I don't know. I don't know. What I firmly believe, though, in this case is it was incidental, the possession of the cocaine, which was actually trafficking because of the amount and the way it was packaged. It's incidental to the burglary itself.
Under that argument, then wouldn't an argument be it was incidental to the murder? It was incidental to the assault? Where does that end?
Well, it wouldn't be incidental to if there were a murder. I don't know, Your Honor, maybe it's just a case by case basis, I think, really. And again, I don't recall in the transcript if it was there or what it was, but it was mere minutes after the burglary that the police were called and he was apprehended.
Mr. Allen, anything further? You have a minute or so left if you'd like to use it.
No, ma'am, thank you. We would just ask that the sentencing be reversed and remanded for further sentencing.
All right, thank you very much. Mr. Havlin, thank you. Mr. Allen, thank you. We will take the case under submission and give you a timely written opinion.
Thank you.
Thank you very much.
Thank you.
Goodbye.
Bye-bye.